Hi everyone, how are you? I decided to do the whole theme here around my with an LED crystal ball Katie Joy series. I love Halloween for all of its fun and decor, and it's just something where it goes back historically. Everybody gets along. Not everybody, I know that, but you know what I mean. It brings just so many good feelings of kindergarten, first grade, those first friends you have. And well, I'm from the age where we still bobbed for apples with our teeth and spit and everything, but I'm old, so I'm 51. So I don't know if you guys did that or if that was stopped by the time you guys got in school for good reasoning. But I mean, it was just fun. I had this librarian, and she was really weird. She was a belly dancer, and she had went to one of my I have a real dad, and I have a horrible had my dad has passed on, but and I have a horrible stepfather. Had a horrible stepfather. So when I talk badly about my father figures, it's about my stepfather. My bio father was at a party once with his baseball friends, and my librarian showed up there as the belly dancer. So it was all the big scandal then in the 70s, oh, she's a belly dancer too. And anyway, for Halloween, she said that she found a zombie on the way in, and it had been ran over, and she got its contents. And so we had to blindfold each other and go and feel in the bowls what she found, his intestines and eyeballs. And so it was like a jar or a bowl of cooked noodles and jello, all the things you could get away with in the 70s, right? So I don't know. I just think back to just that fun. And like I've said, I've always had this fascination with big orange pumpkin decor, and just Halloween decor is just really fun for me. It's not the pressure of the holidays where when you don't have enough money for the kids' presents and all of that pressure of everybody getting together for other things. It's just Halloween is just kind of fun. So I love the decor, and this tablecloth just came out. And so I put it up here behind my computer and on the top of my desk just to get into the whole feel as I continue to narrate this the Katie Joy series. Okay, I spent another 2 hours. I went out of town this weekend to North Dakota. My husband saw Pink. I didn't want to go. The tickets were more than I feel like I'm worthy of, because I don't always have a good time. I'm kind of an asshole sometimes around crowds. So I was like, you know what, you go and you have fun. So he got himself a good ticket and went and had a great time. I dropped him off, and I looked into something that I'm really concerned about, just because I don't feel like the whole story is coming out. I feel like we almost had like a Timothy McVeigh incident in North Dakota, when the officer was killed in the line of duty, and two other officers were shot, as well as a bystander, when they were investigating a fender bender. So I just uploaded that video, and I will probably I will be doing more on it, just because I continued to find out more things as I went deeper. And if you listen to it, you'll understand why. They released the body cam from the shooting last Thursday here in Minnesota. So the body cam is quite disturbing, but it needs to be shown because people are under the impression that police don't give warnings before they shoot, and it's important for transparency to start repairing the damage done from. There are bad cops, and my stepfather was a very, very bad cop, and I don't judge police based on the bad ones. I've worked hard not to do that, and so if you get a moment, please listen to that video. I will do more on it, as I say, and I'm back to the Katie Joy series. So after I did my research that I did and recorded from where the assailant had worked at the Fleet Farm, I did my video from there that you'll see. I just uploaded it right now, so it's up. Well, I'll let this one come out. So today is Monday. I'll have this one come out bright and early for you Tuesday morning. But anyway, I spent another 2 hours trying to organize everything to the best way that I could think possible, and made sure there aren't any duplicates, which I did have some duplicates. So where I showed all of the paperwork, there was some that was duplicated, but not a lot. I just am still just shocked that there is this much, due to 7M, because all of this is 7M. And then I've got the other litigations that she's been in back here to show. So there, and I don't have the Tati, everything from Tati's, the whole thing, but I would like to get my hands on all of that as well. If anybody has all of it, please email it to me at TabithaJane0, like the O, the number 0, not ZERO, but TabithaJane0 at gmail.com. I would love to narrate that as well, because all she did when she talked about it was speed read through the last page of it. I think that there's probably more in it that would be revealing. And I think that until the truth and the facts start coming out about Katie Joy and what she really is and isn't, until the facts and the truth come out, she's going to continue to get away with this stuff. And it's gone on long enough. And it's taking a group of us, of strong, confident women that are creating a village of getting together and working together to expose the truth. And as you know, that's Southern Mutton, that's Cactus Bill, that's Nene Marie. Who else am I missing? And there are so many, Llama Girl, Charla. There are so many really great women involved in, they have Facebook groups, they have Twitter, or X as it's called now. I don't know how you'd say X, because, it was hard to say when, on Twitter, what was the past tense for Twitter? Were you supposed to say, oh, I twat? I just twatted. I just tweeted. So now it's even more difficult because it's X. So were you supposed to be like, oh, go X that? Or did you X? I don't know. Just doesn't seem right. You know what I mean? So, anywho, if I missed anybody, I do apologize. Add yourself to my list, and I'll start tagging you when I do my videos, and likewise, and together we can really get some things done. It doesn't do any good when creators fight with the, I don't want to say the word. Oh, it just crossed my mind. I don't want to say it, the M word. Michelle. Didn't want to say it. But it just fell out of my mouth. You guys just heard it. I have been Michelle free for, oh God, it just came out again, didn't it? What, 3 weeks? I think so. Do I get my, do I get my super special AA chips? Because she couldn't get ordinary chips from AA, right? 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 Oh my God, now it's coming back. Oh no. I was clean from Michelle. Oh, now it's coming out for 3 weeks. And oh, where's my chip? Because, she was so special that she had to have really, really special chips. No, she wasn't going. And that's why I exposed her for all of that. So many people were pitting creator against creator in that Michelle shit show that it wasn't even funny. And one of the last videos I did on her creator, just totally started picking a fight with me, and I've talked about that before, and it's just stupid. And that happens here with the Katie Joy too. I mean, because it all goes in the drama community, I guess is what it's called. But I'm pretty much a lone ranger. I'm a lone creator. I'm not part of any community. I do what I want. I come at the stories from the way that I feel, and I don't have any mods. I do everything myself. And I'm still really behind in getting back to everybody's comments. I think I got caught up in my emails this week. I was still a little bit behind, but I had about 600, so I got those all caught up, and then I'm getting my comments all done. So I'm sorry if I have not answered you yet. I do apologize. I'm getting to you. And I did see one horrible Michelle one that somebody had given me, and it was held for review. I'm glad. And I saw a couple of people defending me on the comment. And so thank you so much. I didn't see that. And a couple of you gave me super chats, and I did not see that either. I'm sorry. As I'm getting caught up, I'm very sorry. And so without further ado, I wanted to talk about a couple of things. So as I started this series, I thought that it was just this much. You guys saw that where I did that. And then, I found out it was more. And so when I went through this, I went through the dates, and I got it all. I told you I used an old organizer from years past, and so that I could go and put it through somewhat chronologically. And I got to that part, and then trying to merge it with this part didn't work. And that's where I spent 2 hours trying to get everything right. And then I just figured I can't. I've got to just go the way that I have it and hope that it'll make sense. I just want every single thing out there that has gone on, because she has done nothing but misconstrue the truth. And until people understand that literally there is this much going on, there is 26 pages, as I showed you, of emails going back and forth between attorneys. That is unheard of. Unheard of. My husband looked at the mess of paperwork that I was in the hotel, and he's like, "Are you sorting through Trump's stuff? Like, what is this?" And I'm like, "That's emotion on emotion and on emotion on emotion on emotion to compel on emotion to," and I just don't even know where to begin. And so, as I started narrating, as you know, I started from the beginning. That's the only thing I could really do. And so I will get back to that, but I went out of order for the last one, and I want to continue on that train of thought for this other part, because it still has to do with what I went out of order in, and you'll see why. And then I will get back to going back, line by line through everything, and we will get through all of this, because we know that her attorney is just trying to get caught up. And I have my mammogram this week. If you guys have not had your mammogram yet, schedule your mammogram. I can't stress how important they are. They are not painful. They've came a long way in how they can do things. Check to be sure if your insurance can do, it's called, I can't remember what it's called. It's called something digital. They'll explain it. And if your insurance will cover that, it's really great, because it's so much more accurate. I started doing my mammograms because I started having just kind of some issues in my late 20s. And so many times breast cancer doesn't even show up. So that just tells you that if you're not getting your mammograms and you wait, by the time you actually have symptoms, you just got to be proactive. That's the only way we have a chance to get ahead of breast cancer, is just be proactive. If you have any issues whatsoever, just call your doctor, consult, and most likely they'll just order a mammogram, and that will be it. So I'm going to the doctor this week, which is down by the courthouse. And so I plan on going back into the courthouse to see if anything has been updated on this case, and to get a couple more documents that I'm interested in looking at from the other cases, and making sure that I have everything when I go to narrate all of them. So with that being said, get your mammogram. Get your mammogram. When I was listening to Bill today, and whenever I listen to Bill or Nini, I don't know if you say Nini, Walter's very handsome. Cactus Bill and Nini covered Katie Joy dissing Emily D. Baker. Okay? And Katie Joy said that Emily D. Baker's channel wasn't successful basically until she covered Katie Joy. And here I am in my bubble bath listening to this and listening to Cactus Bill cover it. And I'm sitting there talking to myself in the bubble bath going, what? Emily D. Baker is an attorney, and she was a consultant for talk shows, court TV, etc., etc. I did not know that she covered Katie Joy until that one night when I was doing a live with Possum Wrangler. And Possum Wrangler and I were talking because I wanted to do some healing videos to kind of do some damage control from all of the hurt that Michelle had caused, and I will be getting around to that now that hopefully she's staying further away, and we can kind of because I started that, and then I had too many people that were just broken and hurting because of the things that she had brought up from them. And I still have that in my emails, and I'm still helping people with that. So as soon as I feel like I will not be contributing to any more pain, I would like to get back to that. So Possum Wrangler and I were talking, and we were talking about Michelle, and then Possum Wrangler was talking about Emily D. Baker. And we're talking about Emily D. Baker, and then she said, somehow the conversation got around to Katie Joy. And Possum Wrangler said, Emily D. Baker narrated the Katie Joy thing. And I'm like, what? How did that happen? I mean, I had known about Emily D. Baker way before, and I had watched her for other things. She's a really knowledgeable source of information. Katie Joy talked about her in ways that would make you think that Emily D. Baker is, Jennifer Moore. Attorney for the defendant, Katie Joy. I mean, how can she be insulting Emily D. Baker when she's got the kind of attorney that she does? I'm going, what the? Don't insult Emily D. Baker. I hope Emily D. Baker hears and just goes and just puts a big freaking video out there about you, Katie Joy, because you deserve it. And she then said that Katie Joy was saying that this is a big problem with bloggers and journalists and stuff, that any of us can get sued at any time for libel and slander. And I'm going, no. And she referenced that Rachel Maddow had gotten sued. Well, Rachel Maddow's pretty out there. Okay. It's not a common thing. And to be sued repeatedly by multiple different people, and to have other people that should have and may still, that is not common. She's got a problem. And until she realizes that she's got a problem, she's got many problems. But I wouldn't be putting Emily D. Baker on my list of problems. I mean, why would she talk about Emily D. Baker like that? It's beyond me. Beyond me. So then when I was listening to Bill, Bill had a question about if Nevada is in California, because she is from the land down under. And just like how I wouldn't know, if a city is in a state when I'm in the land down under, I knew where Melbourne was. I knew I was supposed to go to Perth. And beyond that, I really didn't know that much about Australia. So when Cactus Bill asked if Nevada was in California, I totally understand, because looking at a map, it could be in your brain to think that. So Cactus Bill, Nevada is actually not in California. They are a hop, skip, and a jump away from each other, because Las Vegas, Nevada is such a, it's like a hot spot for Californians to hop over. There's a little mountain pass that goes through Barstow, and the Santa Ana winds are just something else. When we moved from Vegas to California, we went through with that pass back and forth, and the winds were just about to knock over my Durango, I swear. And the moving truck, ooh, scary. So I could see how Cactus Bill could think that. And they are separate states. So Nevada is a state next to California. And then Las Vegas is the main city in Nevada. Although it's not. Yeah, it is. I mean, I was going to say it's not the biggest city, but yeah, it is. I was thinking Reno. No. My coffee obviously wore off. So the reason why Tati's product would have been manufactured in Nevada is because a lot of products are manufactured there in Nevada. There's a difference in, I think, the licensing, and they can find cheaper labor, all kinds of stuff. I don't know why, but there does seem to be, if you look at a lot of vitamins, especially, if you look at the back, they'll say that they were packaged in Nevada. So that's where that connection was. And Nevada is not in California, but they are very close. So it would look the same if you were just looking at a map. I could see how you would think that. And then, and I wrote in the comments too, because Cactus Bill thought that, I think she thought maybe Katie Joy's license, her insurance had expired, and I wrote in there that no, it hadn't, because I looked it up too, because it was I guess what do you call it, a myth, I don't know, urban legend that she was no longer licensed, and she actually is. I had to look it up because I didn't believe it either. I couldn't believe that anybody would insure her after the Tati thing, but it is. And so this is here. I have her home address blocked out there, as she is the principal executive office. I have that blocked out there too. So those are just blocked out. If you were to go and look it up, it would show you, just in case you're thinking that, I don't know what I'm talking about, that's the only reason that I have those covered up. So it does show that, that is her status. It is active and in good standing. It shows her file date as 9/22/17, and her renewal date is 12/31 of 24. So it's not even coming up due this year. And then she has her attorneys there as agents, which is interesting to me. When Katie Joy had also mentioned about her insurance and about how bloggers and journalists have to have insurance because of these things, and they have their deductible or principal for whatever. I don't know, but she basically talked about why you need insurance because of that. And this is nothing I'd ever thought of, because I generally have a hold of my mouth, and if I don't and I say something, I better be sure that I can back up what I say in a court of law, and I can and I will. So this is that. Now here's the second part of it. If we look at this, because I wanted to see if there had been a lapse. And so the original filing was in 2017, 2018 it's there. Now, this is where people think that she doesn't have insurance. I see exactly what happened, because on 3/20 of 2019, it says administrative termination, limited liability companies, domestic. Okay. So it says that it was terminated. Okay. Now, if we look over here, it says that it's, it looks like it's been continuous, but it hasn't, because it has had that lapse. And that's where I think that people would think that, because it says administrative termination on 3/20, and then 4/17, it says annual reinstatement. I'm assuming she didn't make a payment, because it was not active for about a month, from 3/20/2019 to 4/17 of 2019. It was not active. So there was that 1 month lapse in 2019. Now, if we look over here, then we see again where 2/1/23, it says administrative termination, domestic. And you're going, okay, she didn't have it. But then 6/28/23 says annual reinstatement. Why was it at a lapse for that long? I don't know. And I don't know what the administrative termination means. I don't know if that's when she changed attorneys and put a different attorney on record. I don't know, because I don't know about this stuff, because I don't go running my mouth like her. But as you can see, she did have insurance at the time of this filing. They'd have been lucky to have not renewed her, but she's in there. She's got it. And the way that it reads right here looks like it's just fine. That's why you always have to go past things. When you look up a license or something like that, you see, okay, active in good standing. You just always want to see in the filing history and go down. Of course, that's where the issue was with Michelle. I said it again. When people were saying that, oh no, she's an insurance agent, and I looked it up myself and saw, nope, she was an insurance agent for about 2 weeks, and she screwed that up. That license was terminated. So, I fell off the wagon with my Michelling today. Lord, what am I gonna do? So that's what I was talking to Bill about when I was in the bathtub listening to her video, and I wrote a couple comments in Bill's thing and said I would do a video and continue talking to her. So I am talking to her and all of you as I look at this. So there's that. There's that. And now, when I was talking the other night, I told y'all that I needed to come out of the series that we're doing in order because of all of the questions that are going on in Reddit and everywhere else based on Katie Joy's misinformation. when she said, "Oh yeah, I'm doing everything right. It's the other side that's not doing anything. Oh yeah, I'm not in any trouble." And the judge is really mad because people were illegally streaming it, and the judge is really mad. And so no, we're not doing anything wrong. The other side isn't doing anything. No, bullshit, bullshit, Katie Joy, bullshit, 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 bullshit. Okay, bullshit, bullshit. Nothing could be further from the truth. And I showed you that. I wanted to kind of do some damage control right away, just kind of put a quick band-aid on the big bleeder here and show you that that's not true at all. And then we'll keep going through this. So what I showed you was the protective order. And I read that to you, and that protective order gave us a lot of information to glean in on what's really going on. And then the 26 pages of emails going back and forth showing that, no, both sides are back and forth communicating. It's not that her side is victorious in any way, as I told you all. Quite the opposite. And the other thing I wondered about when I was listening to Bill was Katie Joy. Bill played the older deleted Katie Joy video where she was talking about the Tati one, and she had an attorney, the last name Brown, I believe, Michael Brown, is that right? And she thanked him so much for his hard work and whatnot. How come she didn't retain him again? Did he refuse to represent her again? Why is it a different attorney? I mean, did he did he curse the day he took her case? What happened? I think it raises questions to get a different attorney when you're being brought to court for the same issue. If you have an attorney who believes in you and defends you and wins, essentially, in the way that she thinks, then why wouldn't she have him again? Very, very interesting. Raises a lot of questions. Definitely. So, to put this other piece in there to continue to kind of let everybody know that, oh, there's some deep stuff happening. And then we go back to this. I wanted everybody to remember that Amber Stavig, or Xena Warrior Princess, as I kind of think of her as, really has a handle on things. As I was talking about, it doesn't matter if Katie Joy deletes things, because Amber Stavig is on top of things, and she has all of these exhibits, all listed, and I have them all. I have all of the exhibits and everything, so we'll go through, like, here. So, Instagrams, messages, it's all, so the Exhibit A, we'll go through here. Exhibit B, as you can see, it's all there. So if she continues to post, like I said, it's not a bad idea to take a picture yourself and email it to Amber Stavig. I like I say, I don't think that that's a bad idea at all. I think it's going to take a village to get the truth out and stop allowing somebody who gives Inquirer style, bad paparazzi style reporting a platform. I mean, why has she been so, I don't want to say successful, but when you're making $400,000 a year and you're worth $1.2 million at her age, that's a lot from doing the wrong thing. That's not doing anything to show that it's wrong. The Inquirer sold millions. People who chase people, like what happened to, rest in peace, Lady Diana, those kind of people that chase and go and get things they're not supposed to, do it for a reason, and they do it because they're rewarded. And the reward for her is the attention she gets and the money she gets. And until either or both of those are stopped, she's going to continue and not know that she's doing something wrong. So, as I was saying, we know that discovery has already happened based on the protective order. This was also filed on July 11th, 2023. This one is just saying, so this is an affidavit from Amber in support of plaintiff's motion to compel discovery. Okay. So it's the affidavit of Amber J. Stalvig in support of plaintiff's motion to compel discovery. In that, we have 7M as the plaintiffs. We have Katie Joy, and without a crystal ball, because she talks like she's Betty, and there's two people. In the state of Minnesota. Whoa! Whoa. County of Wright, not Ramsey. Whoa. Oh my goodness. How many errors can I find? That is the County of Wright. Holy moly. Look at that. And this one is written by Amber. Amber, you have somebody writing your stuff that's making mistakes, or you're staying up too late and doing this, because that's a problem right there. And this is just talking about how she attached exhibits A and B of plaintiff's first set of requests for production of documents to defendants and the first set of interrogatories to defendants. And then let's see, Exhibit C is a true and correct copy of defendants' answers to plaintiff's interrogatories. Attached is Exhibit D, a true and correct copy of defendants' answers for production of documents. And then she has Exhibit E as a true and correct copy of the discovery preservation letter sent to Miss Paulson on April 6th of 2022. Attached is Exhibit F, which is a true and correct copy of plaintiff's letter to defendants' counsel regarding their discovery deficiencies, which was served on July 7th, 2023. Okay. So Amber does this where she does good exhibits, and what we have is what she's referring to here, blah, 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 blah. Okay, so she goes through and says this is exhibit the A, B, blah, 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 blah. She does a great job of that. So in here, she's referring to interrogatories and depositions as she has put together the package that then was filed. Now, we don't get to see the depositions and interrogatories in full because some of it is under the protection order. Some of it we can see. And we will, of course, get to that. So, I like how she says this. Further, your affiant saith not. So we know that there's a lot going on. That Katie Joy is just acting like nothing's going on. And, oh yeah, that this is going on. And for the people who logged into the Zoom link, they didn't do anything wrong. There's nothing wrong there. If something cannot be discussed due to the protective order, the judge and the attorney will say so. They will say, we need to confer, this information cannot be on the Zoom link, etc., etc., and they will pause that part and then go back. Wright County has most everything open to the public. When I inquired several times, probably, I think, 5 or 6 times on this, like, is this going to be closed? Is this going to be closed? Because Katie Joy would like you to think that it's not open to the public. They're always looking at me like, what are you talking about? Everything's public. So don't let her intimidate people into thinking that it's not. Now, this is important, I think, to do before we go further, because this is more about what is going on with the discovery and who's dropping the ball, the crystal ball, not a crystal ball. So we go in here and we go back to state of Minnesota, County of Wright, definitely, not Ramsey. And we've got 7M as the plaintiffs versus Katie Joy, and this is the memorandum supporting the defendant's second motion to compel. Okay, so that's saying this is the second time that they've had to do this. And we go in and we say, the introduction states, and this is authored by her counsel. Surprise, surprise. Okay. So, Jennifer Moore authored this. Hold on for the ride. Plaintiff's response to defendant's second motion to compel misstates the burden of persuasion with respect to motions to compel and ignores the substantive content of defendant's motion outlining the efforts made to narrow the issues for the court. It also ignores the fact that plaintiffs had failed their own obligations to secure their rights under the rules. I don't like how she started a sentence with it. Anyway, plaintiff's response to defendant's second motion to compel is wholly consistent with an intention to prevent defendants from defending a lawsuit that was likely brought as a strategic message to prevent others from negatively reporting upon them. It is certainly not consistent with foundational precedent that provides that, quote, mutual knowledge of all of the relevant facts gathered by both parties is essential to proper litigation. Jepson versus Swanson, 243 Minnesota, 547, 551, 68 NW, 2D, 649, 651, quoting Hickman versus Taylor, 329 U.S., 495, 507, 67 SCT, 385, 392, 91 L edition 451, 460, and 1947. Moreover, plaintiffs have failed to set forth a substantive response to defendants' request to amend the protective order, probably because to do so, plaintiffs would need to explain to the court why it believes that any party is advantaged by a protective order that contains structural barriers to enforcement of its right thereunder. Ooh, she was hot. She was hot. I mean, that's some big speaking there from Jennifer. The argument. Plaintiffs have the burden of persuasion to establish that objections to discover are proper. It is well-settled law that a party seeking to limit discovery must establish grounds for not providing the discovery that are specific and factual. The party cannot meet its burden by making conclusory allegation. Hill versus Auto Owners Insurance Company, number 514 CV 05037, TAC KES 2015 WL 1280016 at *7 DSD March 20th 2015, citing Burns versus Imagine Films Entertainment Incorporated, 164 FRD 589 593 WDNY 1996. Plaintiffs appear to understand this burden by citing Underhull versus Commissioner of Public Safety, 735 NW2D 706 712, Minnesota 2007. The party objecting to the production of information has the burden of establishing that the sought-after information is immune from discovery. However, plaintiffs turn this well-settled burden of persuasion upside down by telling the court that its defendants' obligation to say why plaintiffs' objections are not valid. Ooh. Plaintiffs appear to believe that the language of Minnesota, our General Practice 115.05, somehow shifts the burden onto defendants. That rule provides, for motions involving discovery requests, the moving party's memorandum shall set forth only the particular discovery requests and the response or objection thereto which are the subject of the motion, and a concise recitation of why the response or objection is improper. Ooh, girl, she's on fire. I mean, this is where Jennifer Moore is earning her money. She didn't bring that fire to court the other day, I'm going to tell you that. All right, so in a case such as this, the concise statement is not meant to shift the burden of proof. It is meant to permit the court to examine each discovery request in an organized way. The rule also provides that memoranda and reply memoranda may not exceed 35 pages except by leave of court. The rule is premised on the belief that by the time a matter reaches the court, the parties should have made some effort to communicate such that they have a basic understanding of the other's arguments. But it does not shift the burden of persuasion onto the moving party. Okay, they started a sentence with the word but, and they're talking about it's, oh. Anywho, this was asterisk down here that the defendants note that the plaintiff's memorandum supporting its motion to compel fails to comply with this rule in that it did not set forth defendants' responses. Okay. Page 3 of this fire. Plaintiff's allocation of the burden of persuasion would place the defendants in an impossible situation. Defendants do not know what information is in plaintiff's possession. Thus, it would be impossible for defendants to formulate a response to an objection that the discovery sought is unduly broad or overly burdensome in proportion to the needs of the case. And plaintiffs have not helped the court by not providing any factual basis for its objections. In presenting defendant's defense to plaintiff's motion to compel, counsel described the efforts she made to locate the statements that plaintiffs claimed to be defamatory. Counsel explained that some statements that plaintiffs alleged to be defamatory were never made. Others may be contained in social media posts referenced in the complaint with links that are no longer valid. Okay. Links that are no longer valid? What the? Okay. All right. This is where we're getting to this where I don't think that her counsel understands the brevity of the situation here. This is me talking, I'm not reading. To say that the link is no longer valid, that's kind of what she was alluding to when she was in court. She was like, well, we can't find them, and what they're talking about isn't there. Well, you know what? That's why they have all of this. That's why they have everything all copied. That's why they have it. It doesn't matter if the link isn't valid anymore. It matters that it was there, and they have it, and they preserved it because they knew what she would do. It doesn't matter if it's no longer valid. It matters that it was done. Oh, anywho. Counsel further explained that it is difficult to identify sources and a factual basis for statements without a specific citation. Okay. Based on what I've seen, they have everything all documented. I don't know what she's doing here. This is exactly the sort of detail that would support a court's order limiting discovery. Plaintiffs have provided no explanation at all why their objections are valid, though. Moreover, even though it is the plaintiff's burden to establish that it is appropriate to limit discovery, defendants undertook a detailed analysis of the discovery sought and the objections asserted by plaintiffs as to each interrogatory and request to produce documents which form the basis of defendants' motion to compel. For example, defendants explained that plaintiff's response to interrogatory number 9, seeking information about guilty pleas to criminal offenses, was inadequate. Okay, and now they're going to cite that. She's got a little citation here, so here we go. I'm drinking my blackberry lemonade tea, my favorite thing. Ragweed pollen is out horribly out here. Do you guys have that too? We're in a heat bubble, and the ragweed is just horrible. So I'm on all my allergy medications and sipping my tea. But not hot tea as I should be. Anywho. Here we go with what she is referring to, what she is citing here. Okay. So, defendants are baffled by this response. It would appear that one or more of the plaintiffs have been convicted or pled guilty to a criminal offense. Otherwise, the appropriate response to the interrogatory would have been easy. Apparently, plaintiffs expect the defendants to engage in a 50-state search of court records to locate information that plaintiffs have in their possession. That is an absurd interpretation of the rules of civil procedure. This information is not sought to embarrass the plaintiffs, but rather to determine whether there is a criminal conviction that could be used to impair their credibility as a witness. Okay. And then it says, defining def mem supplemental 2. So it must be, defining the memorandum supplemental second motion to compel at 10. This analysis fully addresses plaintiff's objection that the information is publicly available, not relevant, and sought to harass and embarrass parties. Okay, I'm having a little bit of deja day here. Because literally, when I was listening to Cactus Bill, that's something that was stated about the Tati lawsuit. Literally. Are you guys thinking that too? That they said something very similar. So they're defending her, saying the same thing, that she couldn't have done this. This would have. Oh, wow. Do you guys know what I'm saying? Are you guys like jumping up and down going, yes, yes? Tell me in the comments. Tell me in the comments. Because I'm going, wait a minute. Am I imagining this? No. So what did they do? Go back to the other lawsuit and see, how do we do this? And then copy and paste? Maybe so. Maybe so. Trying to figure out how to defend her cannot be easy. Now it says, plaintiffs also ignore the fact that by ignoring their obligation to timely object to discovery, they have waived the right to object except on the basis of privilege, work products, and experts' conclusions. Citing Private Bank, Minnesota versus Anderson, number 813, TAC 1570, 2014 in Minnesota Appeals, unpublished in the LexisNexis 303 at *7, April 7, 2014, extending the holding of Garrity versus Kemper Motor Sales, 159 Northwest, 2D 103, 106 through 7, Minnesota, 1985, to cases arising under the current rule. Thus, the court need not undertake the effort to examine any of the plaintiff's objections, except for privilege, work product, or experts' conclusions. All right. So, plaintiffs failed to respond to efforts to narrow these issues for this motion. Counsel must admit that plaintiffs' argument that defendants failed to certify that they attempted to meet and confer inspired some amount of outrage. Minnesota R Civil Procedure 37.2 does require the parties to set forth the efforts undertaken to resolve discovery issues. Counsel's declaration supporting defendant's motion to compel indicates that she attempted to secure plaintiff's participation in narrowing these discovery issues in letters dated March 27, 2023, April 28, 2023, and June 12, 2023. Plaintiffs did not respond to these letters until sometime after 11 p.m. on July 10th, the day before a briefing on the motions were due. Defendant submissions further outlined the fact that plaintiffs did not attempt to engage in discussions as to defendants' discovery responses until July 7th, 2023. Despite this extremely tardy response, defendants were able to adjust its arguments in half-prepared briefing to reflect the arguments and supplemental discovery made by plaintiffs therein. Okay, what in the actual F? Because this is not the attitude that was brought in front of the judge at all. In fact, Jennifer Moore had used the defense that she went on a vacation and she was gone and then came back and it was all there. And then, after some muttering and stuff, I was gone for July 4th. Well, this is July 7th. So, Jennifer Moore is basically blaming the other side for being tardy. In court, she was the one proven to be tardy and not doing these things and not narrowing these motions. So I don't know what kind of a fire she had up her ass this freaking night, but she wrote some stuff. And this is where Katie Joy could have taken this right here and been that cocky and said, yep, the other side isn't doing anything, blah, 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 blah. Well, let's look at all this. There's all this going on. But you know what? Jennifer Moore was all fired up. And she did all this. But I'm telling you, maybe somebody else wrote all this, because this is not the behavior of the attorney in that courtroom. So anyway, she goes on and mouths off this. You ready for this one? I can just see this one right here where I'm seeing this. Oh, man. She says, perhaps plaintiffs believe that the rule requires some magic language rather than a substantive discussion of the efforts defendants made to resolve discovery disputes. It does not. Okay. Once again, don't start a sentence with it. Ugh. And to say it requires some magic language. Okay, quantify magic language. Is that saying zippity-doo-dah? I mean, ugh. This is really tacky. Tacky, and unprofessional. Moreover, I'll go back to reading. I hope you guys can tell which ones are my comments and when I'm reading. I should be better about saying this as me going off. No, I cannot believe this. So I'm sure that Amber was ready to have a smackdown. Then she sees the grandma there, like, oh, I was on vacation. I don't know who wrote this. Anyway, she signed it, but I don't know that she did it. Anyway. Moreover, even if the rule did require a formal certification, the remedy for failure to secure such a certification would be to adjourn the proceedings to require the parties to make additional efforts to resolve the discovery disputes. Defendants submit that it would be inappropriate in this case. Plaintiffs have failed to be persuaded by the arguments made in connection with these filings and have made no effort to clarify the basis for their objections or to offer additional discovery. Ooh, girl. I don't know about all this. Well, here we are. 3. The terms of the protective order permit amendment. Plaintiff's only response to defendants' request to amend the protective order is that defendants have not cited any authority permitting such an amendment. Paragraph 9 of the order provides that any party that may apply to the court for a modification of the protective order. Order at 3, February 7, 2023. Clearly, defendants are entitled to seek amendment of the protective order, and the protective order should be amended based on the fact that plaintiffs have designated every shred of paper as confidential, and the time and effort to object to each designation under the terms of the existing order are not consistent with the just, speedy, and inexpensive determination of every action. Minnesota regarding Civil Practice 1. Conclusion. For the reasons stated herein, the court should issue an order compelling plaintiffs to answer discovery and amending the protective order to permit a challenge to confidentiality designation to be made and presented to the court at such time as it becomes necessary to assert such challenges. Respectfully submitted. Troutman Martin Law. Signed by Jennifer Moore. All right. Attorneys for the defendant. Dated July 25th, 2023. So, we had a lot of people wondering what was going on the July 19th. And that's where we still don't have receipt of what happened July 19th. We can glean in and say that it was most likely these issues, the answers to discovery that are under the protective order. So they might have been submitted. Everything was all there. because the dates are consistent with it. If we look at here where the affidavit in support of plaintiff's motion to compel discovery, that this was dated July 11th, 2023. And then when we look into this reply memorandum supporting defendant's second motion to compel, and we see that Jennifer Moore dated this July 25th, 2023. So we can see that a lot was going on there towards the end of July. We know something happened on the 19th because we have it in the records, but what it was is most likely just under that thing, just under the protective order. Now, this is where I've shown you this, and this was the proposed order. This was done before they came in, okay? So this was made available. Well, this was dated July 11th. So what this is notice of motion and motion to compel discovery responses. In this is the hearing that I went to and reported on, because it says here, please take notice that at 9 a.m. on Tuesday, August 1, at the Wright County District Court, blah, 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 will bring on for hearing before the Honorable Judge Carrie Willis, Judge of District Court, their motion to compel discovery responses for defendants, okay? So you have this here. This is what was going to happen. This is what should have happened. This was the script for that day. This is what that day was supposed to hold. And in here, it was supposed to be, the motion was, the plaintiffs will and hereby do move the court at the above stated time and place for the following: for a motion to compel discovery responses pursuant to 37.01 of the Minnesota Rules of Civil Procedure and other applicable law. This motion is brought pursuant to the Minnesota Rules of Civil Procedure and will be based upon the files, records, and proceedings herein and the supporting memorandum and declaration submitted in accordance with the rules, together with such additional oral and documentary evidence as may be presented in connection with the hearing of this motion. And that was dated July 11th of 2023 and signed by Amber. And then it says here that the acknowledgement is that the undersigned hereby acknowledges that sanctions may be imposed pursuant to Minnesota Statute 549.211 against the attorney, law firm, or party that has violated or is responsible for the violations of Minnesota Statute 549.211 subdivision 2. And that's dated July 11th, 23. So this is what she went in there to do. She went in there to say, what in the was that you threw at me here? That you want to throw this here at me and do this when you haven't done this? Because this is very strongly worded for somebody who went in there and said, I was on vacation. Okay. They were there to settle things. If a judge was going by the book, they could have settled it. They could have said, this side isn't doing this side isn't doing that, and for either side, and said, this is done, or write a check. But as I told you, the judge didn't do that. The judge looked at all of this mess, said, where are we? Why can't you come to a conclusion? Why can't you two talk? Why can't you get anything done? And the players picked their fighters. And nothing could be more clear than the character of each attorney to show what's going on. As stated, one is very, very in tune to social media and its repercussions. The other one has no idea what a mess her client has created, quite frankly, in my opinion. Katie Joy's in trouble. I really feel like she has no idea what she did here. With the Tati thing, it was jurisdiction. It really was. To go and try and file, it's very difficult because where is the jurisdiction of the internet? When you say something on the internet, you have an audience worldwide. So is there a worldwide court to go to for all the damage that you've done everywhere? No. So where is the jurisdiction? How many people are affected by what she says? Or what anyone says? The Tati lawsuit didn't teach her anything. It didn't teach her that you shouldn't be so specific in what you say. I mean, leave something to the imagination if you're gonna run your freaking mouth. Don't use the person's whole first and last name. I mean, there's a lot of creative ways that people word things to not put themselves in these positions. I don't know why she went so hard for Tati. I mean, if she, I don't want to get myself in trouble here, but I mean, looking at Katie Joy's hair, if she had somebody to blame for a product that did that to her hair, but it appears to be a hairline issue, I don't freaking know. But why would she care so much about somebody who makes a hair supplement? I have no, it is just beyond me. I don't know why she just goes for women. She goes for beautiful women. She goes for beautiful, functional, happy, healthy women with families, with children, with careers that are successful and happy, and just goes to obliterate them. A misogynist is technically a term for a man that hates a woman. But I think that the term applies to her. In my opinion, she's a misogynist. She hates women. The behavior that she exhibits towards other women, especially other mothers. I mean, I watched probably every episode of the Duggars when they were on TLC until it got ridiculous. And then it was, on the spinoffs and stuff. But what I learned was, okay, this is how they shop and they save money that way. And they make tater tot casserole ahead of time in the freezer. Well, that's a great thing. I should think of things like that. That's what I watched and thought, I was like, oh, why don't I, have a day where I make several big batches of tater tot casserole and put it in the freezer so I have like 5 on hand at any time, so that we don't go and say we don't feel like cooking, so let's hit McDonald's. Something like that. I mean, like, that's what I got out of it. And watching them grocery shop and how everything was down to a science, and how interesting it was, and how they have a system in each child, watches for the other one, blah, blah, blah. I never once thought, oh, wow, why don't I say something nasty about the Duggars? And, oh, my gosh, well, this one's pregnant again. And, oh, my gosh. And you know what? I heard from this one about Ginger. And, oh, my God. I never once thought I should be spiteful about them. When it came down to the mom not having a baby for how many years, they had the very sad loss. And then the show was going on, and it just had her sitting with the kids, and she was trying to like play a board game with the boys, and it showed that she really didn't have a lot of like, there wasn't much more to the mom than what she did in child rearing. And I mean, she only did that. I mean, only what, raised 17 kids. I mean, honestly, but it's like her whole focus was on the children, on childbirth, on homemaking, and doing everything successfully. So when it came down to her playing a board game, she just really didn't know what to do. She seemed very bored because she had just been so freaking busy all of those years. And so, I noticed that, but it wasn't like I went and was like, I'm going to go talk and say that, oh my gosh, she's not sophisticated. It was nothing like that. It was like, wow, just curiosity. I mean, TLC was the learning channel, learning about other people and other cultures. And before the internet, I mean, that's how you would have an insight into other people's lives and other, ways of life that aren't common everyday experiences. I just never saw anything spiteful. I mean, of course, what the scandals that came out, I could see, if I had a channel speaking about that, but not anything to like what she does. It just doesn't make sense. And like I tell you guys, she's nothing. She can go anywhere she wants out here, and no one would ever know her. No one would ever be like we don't even have, like, our towns are kind of weird, and she very much lives in a remote area. And so we don't really have like a central downtown like the town I grew up in did. Or maybe then people would know her, but I don't know. It's not like she could, I mean, she can go into any store and no one's gonna be like, oh my gosh, that's Katie Joy. It would never happen. Would never happen. Ever. Not that she ever leaves her house. But anyway, here's my LED crystal ball. I saw this crystal ball in Bath and Body Works today. Have you guys seen the Bath and Body Works setup yet for Halloween? It is incredible. I want their cardboard stuff. I bet you that somebody's already asked them if they can have all their stuff when they're done, but my ass might just go out the day after Halloween and go through their dumpster and see if I can find if they threw the stuff away, because the stuff is incredible. And they have this crystal ball, and the freaking thing is $69.95. I had a coupon for that came through for Bath and Body Works for $10 off of $30. And so I marched my happy ass into the Bath and Body Works, and I was like, oh yeah, I have all that stuff. I'm going to go there and I'm going to get something. And I lifted it up. It's $69.95. I'm like, what the? And then everything else is like the plugins, everything. And I'm like, nope. So I was so good. I walked into Bath and Body Works and I got my free item that I had earned for my points, and I walked back out because everything else is so expensive, and I have so many other things. I do not need anything more, but oh my gosh, when you see it, it's just, it's so difficult. So I just wandered around there by myself and looked at everything and got it out of my system just looking at everything. But you have to go and check out Bath and Body Works if you haven't yet. Oh my gosh. And the free item I got was the pumpkin pecan waffle body cream. Smells amazing. So amazing. So anywho, this will be part 8. We'll do part 8, and then I'll get back to going back through this all so we can be all caught up by the next time they go to court, which who knows when that will be based on what we've had. We'll just start hacking away at this. I don't have any more out of town events scheduled, so I will just be hammering away on this and a couple other little projects, and we'll start figuring all this out. Okay, we're gonna get to the bottom of this, of the truth and the facts. All right. Well, thank you for listening, and if you liked listening today, please give me a like and please subscribe. And if you really liked it, you could buy me coffee. My Cash App is Tabitha Jane 13. It's got a little picture of my boo-boo cat. I put a picture of him with this background on my community page, because you can see, because when I was getting all this ready, he wanted to be a big part of it, and then he did his thing, and he walked all over my keyboard like he usually does, and oh yes, until I give him one of his treats, and then he was okay, and he marched off. So, if you want to buy me coffee, please give me a little tip there on my Cash App. And I will talk to you guys again soon. Thanks for listening, and thank you for all of the love that you send me. I really appreciate it. Thank you. Bye-bye.